everyone, and good evening. Unlike Professor Bowries, I have no excuse for the way I look. It is a pleasure and an honor to be here, to be invited to participate in this. I think that the objective of the Lincoln Douglas Society is exactly what law schools should seek: the exchange of ideas on important topics, civility, intellectual diversity. It is all exactly what we hope law schools to be. And so it is a delight for me to be here and to play a role in it. It is also a delight to work with Grant and to have prepared my remarks with him. I should note, however, although this organization is called the Lincoln Douglas Society, that given the subject of today's talks, I wonder if it might better use the names of the two other most famous American political debaters, Kennedy and Nixon, given that one of them is famous, or perhaps infamous, for saying that when the president does it, that means that it is not illegal. I don't know, maybe you even would have been on your side, since he also said, I welcome this kind of investigation because the American people need to know whether or not their president's a crook. It is an honor, but a difficult task to be here today because the opponents of granting me are so esteemed and so worthy. Professor Scott Bowries is a professor here at the USC Rice School of Law, is an expert in constitutional law. He has a JD and a PhD from the University of Florida. He clerked on the 11th Circuit for Judge Cox, and he taught for 14 years in Kentucky before coming here in 2022. Maggie Cruiser is a student here at the Rice School of Law and a graduate of UNC Chapel Hill, an institution that I've heard sometimes wrongfully refers to itself as Carolina. She comes here not only with an exemplary academic record, but with experience as a teacher in mathematics for 4 years before she began her legal studies. It is an honor to go against them, to have them as our opponents here. Please welcome them. I would have been perfectly fine without opponents who were quite so good. I want to discuss two main propositions, two main reasons why presidential immunity was granted and why it's necessary. That, in short, is because without presidential immunity, presidents in office, anticipating being former presidents, would fear threats both from within the executive branch and from outside the executive branch. And thus, there are arguments grounded in executive branch practice, a practical fear, the kind of hesitation that we don't want our president to have to endure, and separation of powers concerns that are caused by potential interferences in presidential administration from Congress and from the judiciary. Judging from the press attention that this case got, and a lot of popular discussion about it, you might have thought that presidential immunity was something that was developed by the Supreme Court or by Trump's lawyers over the course of the last year or two. But that is not true. As Professor Bowries mentioned at the very end of his remarks, presidential immunity has been around for more than 40 years. The principal precedent to that effect is Nixon versus Fitzgerald, a case decided in 1982. And yes, it is true that Fitzgerald involved a civil case. But the arguments in favor of the immunity that the court granted in the Fitzgerald case are very much parallel to the arguments that are applicable here. Fitzgerald involved a claim, a civil suit for damages against, by then, former President Nixon for alleged illegalities, for basically having Fitzgerald, who was a Defense Department employee, fired through part of a governmental reorganization. He claimed that Nixon didn't like him because he was a whistleblower of some sort. And that was his lawsuit. Supreme Court says even if Nixon's behavior was illegal, in fact, even if Nixon knew at the time he took the behavior that it was illegal, he was absolutely immune from damages. And the reason was a very practical one. The court said, we don't want our president, while in office, looking over his shoulder and making calculations about his own potential liability. We want our president to be making decisions for us. That is to say, on the basis of his own view of the public interest. We don't want the president to say, I think the better approach, the better decision would be X. But if I do X, there's a pretty good chance that I'm going to be sued after I leave office. And so I better do Y. I think I should reorganize the government, cut some jobs in the Department of Defense. But if I do that, I'm going to get sued by some disappointed officeholder. We don't want the president making decisions on the basis of those kinds of personal concerns. It is better that we free up the president to be able to make the decisions on the basis of his own view of the public interest. Now, this rationale, although it was exculpated by the Supreme Court in 1982 with respect to the president, is by no means exclusive to the president. As Professor Poeries mentioned, the Speech and Debate Clause provides similar immunity to legislators, that is, members of Congress. But the Supreme Court has interpreted the Speech or Debate Clause more broadly than the Speech or Debate Clause itself suggests, extending similar immunity to state legislators, who obviously are not covered by the federal Speech or Debate Clause at all, and even congressional aides when they are helping members of Congress carry out their tasks. The objective, of course, is the same kind of functional consideration. We want members of Congress to be able to carry out their functions. If the threat of a lawsuit is getting in the way, we want to free them up from that obstruction. Similarly, judges are absolutely immune from damages on precisely this rationale. We don't want judges deciding cases by worrying about which decision, which result would open them up to greater liability. And so we say, even if a judge makes a decision that is wrong, that is illegal, that goes beyond his jurisdiction, unless the decision is so far beyond his jurisdiction that there's no plausible claim of legitimate authority, we provide immunity to that judge. The only difference between established law on immunity and this case is the one that Professor Poeries mentioned, that this case involves a criminal prosecution, whereas Fitzgerald, etc., involved civil lawsuits. But that's not a basis for distinguishing the two. The argument, the basis of this trepidation, this looking over the shoulder kind of worry, is at least as applicable in the criminal context as it is in the civil context. If you thought somebody who was president would be fearful of making the right decision because he was worried about being sued for a certain amount of money, imagine the kind of effect if a president was worried about being locked in prison. If you want the president to be able to focus on doing the job of being the president without having to worry about ending up in court afterwards, some form of immunity is necessary. And by the way, when we're talking about immunity, it is, of course, possible that immunity would end up making it impossible to punish a president for actions that are illegal. But immunity helps the president who has not necessarily committed any kind of crime, but doesn't need to put up with the hassle, the time, the expense, the indignity of being prosecuted or being stuck in court afterwards. Think, for example, of what would happen if President Biden, after he leaves office, were to be prosecuted for various failures for enforcing the immigration laws, say. Now, maybe he's not guilty of those. Maybe what he has done or what he has decided not to do isn't a crime. Maybe it's a valid interpretation of the various laws. But if you were President Biden and you knew that taking a certain action while in office would open you up to the possibility of prosecution or even civil lawsuits, you might think twice about taking that kind of action, even if you thought that the action that you wanted to do was in the public interest and legal. So immunity doesn't necessarily protect only the wrongdoer, it protects the vigorous executive. Now, second point, the separation of powers point. Everybody realizes, and I don't think I would get any objection to this point from the other side, that there must be at least some presidential immunity from criminal prosecution. Suppose the statutes were written in a way to make this possible. Suppose that a president issues a pardon. Suppose President Ford pardons President Nixon. Or suppose President Clinton pardons a notorious campaign donor. Or suppose President Biden pardons his son. And then suppose after the president leaves office, the president is prosecuted for obstructing justice. Now, the pardon power itself carries with it, it seems to me, an implicit command that exercises of the pardon power not be subject to prosecution of the president who exercises the pardon power. If we allowed Congress to punish exercises of presidential authority, we would get rid of that piece of presidential authority. Professor Bowery's talked about the structure of the American Constitution. The most important part of the structure of the American Constitution is its division of authority between the states and the national government in terms of federalism and between the different branches of the national government, what we call separation of powers. The framers deliberately decided not to adopt a parliamentary system where the executive is subordinate to the legislature. The legislature can make the rules, can tell the executive how the executive has to implement the law. We don't have that system here. Article 2 gives the president the power to take care that the laws be faithfully executed, even if Congress would prefer the laws to be executed in a different way. If we are to maintain that distinction, giving the president some authority to act in executing the laws in the way that he thinks is most faithful to the laws and to the Constitution, we cannot permit Congress to criminalize the way that the president takes care that the laws be faithfully executed, unless the president kowtows to Congress and executes the laws the way that Congress wants. The whole point of creating a separate, independent presidency was to allow the president to have that kind of independence and to be able to exercise those powers independently of Congress. So, for those two reasons, that immunity is indispensable, both to protect the president from weakness in fearing the next occupant of the White House, and because immunity is necessary to protect the president from encroachments by Congress and the judiciary, I ask that you vote no on the proposition. Thank you.